The Supreme Court of Canada has upheld the Vuntut Gwitchen First Nation's requirement that elected officials must reside in the community. The First Nation requires all elected officials to live in the community of Old Crow or move there in 14 days. Vuntut citizen Cindy Dickson ran for council in 2018, but she was barred from running because she lives in Whitehorse, 800 kilometers away. She took the matter to court, arguing her equality rights are guaranteed in the Canadian Charter of Rights and Freedoms. Vuntut Gwitchen argued as a self-governing First Nation, it has its own constitution and the charter doesn't apply to them, and it had a right to govern itself in order to preserve its culture and traditions. The Supreme Court ultimately found the charter does apply to the First Nation, but it also found the First Nation's residency requirement infringed upon Dickson's right to equality. However, Dickson lost because the court found Section 25 of the Charter, which upholds the collective rights of Indigenous people, ultimately prevails over an individual's equality rights. Chief Pauline Frost welcomes the decision.
It's always our intention to protect Aboriginal rights and treaty rights and inherent rights of our community. And we are a self-governing Indigenous community. And our seat of our government is on our settlement area. It always has been historically.
She hopes the outcome doesn't dissuade other citizens from running in the future.
We will do our utmost to ensure that they're relocated in due course and that they're supported when they relocate and that we find them appropriate accommodations, that we don't want this to ever be seen as a restrictive process.
Dickson's lawyer said in a statement they're pleased the court confirmed Vuntut Gwitchen people have charter rights in relation to their Indigenous government, among other things. However, they're disappointed with the result. Sarah Connors, APTN National News, Whitehorse.